Hi folks, and welcome back to Conveyancing. This is the final video in the video series for formation of contract, and we're finishing off module 2. The last video we had a little look at installment contracts, and this video we will have a look at prohibited transactions and just briefly touch on the deposit. So without further ado, let's look at prohibited transactions. There's 3 topics that we really need to get across for this issue. The first one is section 57A1 of the Property Law Act. The second is 57A2. And the last one is transactions that are prohibited by acts. Looking firstly at section 57A1 of the PLA, this little provision was inserted in 1982, and I thought that you might like to see it in all its original glory. It was enacted to kind of address the perceived problem of subordinate legislation being found to have impliedly rendered contracts void or unenforceable. And to minimise that, the legislature thought, well, the subordinate legislation is going to have to be pretty clear about its intent before contracts are going to be rendered void or unenforceable. So they cleaned it up a little bit here, tried to make things a little bit more clear. So it says an instrument of subordinate legislation shall not have the effect of rendering void or unenforceable any contract or dealing concerning property that's made, entered into, or effected contrary to the legislation, unless in the case of an instrument duly made by the Governing Council, it expressly provides that such a contract or dealing shall be void or unenforceable. Okay, so it's going to have to be a very, very clear intent expressed on the face of the subordinate legislation before it's going to render a contract void for non-compliance with that subordinate legislation. Subsequently, there was a bit of a rethink here because subordinate legislation, or the more modern term is statutory instruments, don't necessarily go through all the checks and balances that normal acts do in their passage through Parliament. So it was thought that it was far less appropriate for subordinate legislation to actually be able to go ahead and render contracts unenforceable or void for non-compliance with them. So now, since 2017, we have a new 57A sub 1, and have a look at that, and I've put it in really big, really yellow writing for you. The statutory instrument, so they've updated the terminology. A statutory instrument other than prescribed subordinate legislation does not and cannot A, render void or unenforceable any contract or dealing concerning property that is made, entered into, or effected contrary to the statutory instrument. So if you're rather naughty and do something that's contrary to a statutory instrument, or fail to do something that is required by the statutory instrument, it cannot render your contract void. And B, a contract for the sale of land, a statutory instrument cannot give a party to the contract a right to terminate the contract for failure of the other to comply with the statutory instrument. So it has taken a lot of the wind out of the sails of statutory instruments now, and they're a lot more, I guess you'd say, toothless than what they used to be. So if you're wondering what a statutory instrument is defined as by the legislation, you might ponder to yourself, does the Acts Interpretation Act cover this? Yes, it does, but then it just points you to the Statutory Instruments Act, and in section 7 of the Statutory Instruments Act you'll find the meaning of statutory instrument. Something that satisfies subsections 2 or 3 has to be an instrument made under an act, under another statutory instrument, or conferred by an act or statutory instrument. And there's all your examples there. One of the following types must be one of the following types: regulation, order in council, rule, local law, bylaw, and so forth. Okay, so that is the Statutory Instruments Act definition of statutory instrument. So this is the type of subordinate legislation that is at play for Section 57A sub 1. Well, as you can imagine, the amendment to Section 57A sub 1 of the PLA has impacted a lot of statutory instruments, one of which is the GCCC, Gold Coast City Council, Local Law number 17. We touched on this in our video series on seller disclosure before contract, and in that video series we had a little look at Section 15, which requires sellers to a land sale contract where a specified work is included. Specified works are defined as things like pontoons and so forth that abut the water or are in or on below the water. If that's the case, then the seller is obliged to disclose or have certain things in the contract that form part of their disclosure to the buyer. You have to tell the buyer that the contract is subject to Local Law number 17. You have to identify the specified work, and you have to say who's responsible for the upkeep of that specified work. Previously, sub 3, as you can see there, if you were naughty and you did not include such provisions in your contract, then if the contract hadn't settled, the buyer could terminate, and under sub 4 they could recover their monies paid. So that is out now, and all of the statutory instruments in Queensland have to be read subject to 57A1. Section 57A sub 2 deals with the effect of an act, so an actual act of Parliament or statutory instrument. Okay, so both of these things. And it states, where an act or statutory instrument requires a certificate, consent or approval relating to any contract or dealing with the property to be tendered before or at the time the contract is entered into, then in the absence of greater particularity, as to time that is, it shall be sufficient compliance with that requirement if the certificate, consent or approval is obtained or tendered as required at or immediately before, and in the case of sale, settlement. So if an act or a statutory instrument requires some form of certificate, consent or approval to be tendered, if the act doesn't actually go ahead and specify with a fair amount of particularity when that has to be tendered, then in the case of a sale, it's sufficient if it's done immediately before settlement. So in Garms and Burns we had similar legislation at issue. In that case, sellers had performed unlicensed building work on their house. Naughty, naughty. The Act said that they shall not sell, the seller must not sell the property at which this unlicensed work had occurred unless first, before contracting, first they had obtained the approval of the Builders Registration Board, and then they had given everyone who proposed to buy a notice of certain matters, providing them with disclosure and information. Now, after contract, but before settlement, the Registration Board gave approval, but the buyer wanted to back out, pointed at the seller and said, your notice was given too late. The court agreed there, particularly because the whole purpose of this provision was notice, was disclosure, okay? Big red flag, there is unlicensed building work on this property that you need to be aware of. That had to happen before the purchaser had entered into the contract and things got messy. Okay, so the purpose of the legislation really adhered in that disclosure happening before contract. But the other issue here was that the notice that the seller was required to provide wasn't the kind of notice, certificate or approval that had to be obtained under the equivalent of Section 57A2. They said that provision really deals with consents and approvals that come directly from a recognised third party, a public authority. So where you've got things like this equivalent this legislation here saying that the Builders Registration Board required the seller to give notice, that kind of notice by the seller is not contemplated by the equivalent of 57A2. The text says, well, let's think about that. Would that happen? Would the same result occur now under the Queensland Building and Construction Commission Act? Again, we had a little look at this in our video series on seller disclosure before contract. They said the upshot was that 57A2 wouldn't assist the buyer. The answer would be no. It wouldn't help them out for the same reasons as in the GARMS case. So whilst 57A2 may have some reach, it's not going to be effective in terms of unlicensed building work. The final thing that we need to get across is where acts themselves, acts of parliament, prohibit contracts or they make contracts unenforceable. Now, acts of parliament are in a very different situation to subordinate legislation or statutory instruments because they have been through that full parliamentary scrutiny process. And so where an act on its face clearly specifies that an agreement is either not going to become effective at all or it's going to be illegal or void and unenforceable, then that is the effect that will flow from that statutory provision. One provision that you might be familiar with in our video series on seller disclosure is the Coastal Protection and Management Act, and that legislation says that if there's some kind of undischarged coastal protection notice or tidal works notice attaching to the property, then the seller has to give the buyer written advice not less than 14 days before settlement. So plenty of notice is required here for the buyer. If not, the agreement's going to be of no effect unless the purchaser goes ahead and ratifies it afterwards. 57A2 won't assist because, again, this is not the kind of consent or approval that is contemplated by 57A2. It is simply a seller having to give a notice as part of its disclosure to the buyer. It's going to have to give a notice that these undischarged coastal protection notice or tidal works notice are there in the background. So the Act will actually render the agreement unenforceable. So that is 57A, and the issue of statutory provisions rendering a contract void or unenforceable. The last thing that we need to discuss now is the deposit, and there's a few things we need to get across here: what it is, what happens when it's not paid, and retention and recovery. That last one's just a bit of a teaser. We're nearly at the end of this video, folks. So what is a deposit? It's a performance guarantee, essentially. So in Howe and Smith, they say it's an earnest to bind the bargain. It creates, by fear of its forfeiture, a motive in the payer to perform the rest of the contract. How true that is, particularly in property transactions where the deposit, as you will recall, 20% of the purchase price is a very significant incentive. The second purpose is that when the contract is performed, the money will be credited against the purchase price. Okay, so it's kind of a part payment of the purchase price. When does it have to be paid? Well, whenever the contract says. You have to be extraordinarily careful to pay by the date that you are supposed to pay by. In the REIQ contracts, this will be stipulated in the reference schedule, and I have included a little screenshot of the reference schedule for you here. The numbers get filled in. You will see that there is provision there for the deposit to be paid in 2 different part payments. So when we were looking at installment contract, the installment contract module just before, we mentioned that a deposit won't lose its character as a deposit even if it's paid in several parts. And you can see in the reference schedule, it's very common that a deposit will be paid in more than one part because, as I said, 20% of $1 million, for example, purchase price of a property is a significant amount of money. So you might pay a small amount up front and then you'll have to go to your bank and arrange for payment of the rest. So that is the reference schedule. How can you pay a deposit? Well, you know, there's plenty of ways to skin a cat, so to speak. Cash, don't know many people that pay in cash, but yes, it does happen. Check, sometimes direct debit, although, as the text says, be very careful if you're going to pay by direct debit because you need to allow for the time lag. So if it takes your bank 3 days to clear a instruction to allow a direct debit, then you're going to have to make sure that the funds will be clear by the date that the deposit is payable. You can have payment by bank guarantees and bonds. We touched on this in week 2 when we were looking at real estate agents and stakeholders, and you can have some real difficulties there for the parties where payment is made by bank guarantee, where the bank guarantee is not made out in the name of the stakeholder. Things can get a little bit tricky there. So, but nevertheless, a very popular means of paying deposit, particularly for larger developments, off the plan developments. If payment by cheque is disturbed in its processing, by any means that is attributable to the buyer, then the buyer will be considered to have failed in their obligation to make payment of the deposit. So where you have post-dated cheques or dishonoured cheques, or instructions are given to the agent not to bank a cheque, in all of these kinds of situations, the buyer will be in default for having failed to make due payment of their deposit. So you can see clause 2.2 of the REIQ contract there just simply states all of that stuff. Failure to pay a deposit is going to be a breach of an essential term, and that will give rise to the seller's right to elect, to decide what to do, whether they wish to affirm the contract and kind of push things uphill and try and get the purchaser to actually go ahead and pay their deposit. How they go about doing that will really depend on whether the deposit was going to be paid to a stakeholder or to the seller themselves. If the buyer was meant to pay the deposit to a stakeholder, then the seller will have to commence an action for specific performance to make the buyer pay the money over to the stakeholder. If the deposit was to be paid to the seller, then the seller is going to have to commence an action in debt for the buyer to pay them the deposit. If the seller decides to terminate, quite simply, you accept the repudiation, you terminate, and you seek your remedies there. Under clause 2.2 sub 3 of the REIQ contract, in this situation, it says that the seller can recover from the buyer as a liquidated debt, any part of the deposit which is not paid when required. Now, just because you decide to go ahead and sue for your liquidated debt and try and get your hands on the deposit, it doesn't mean that the seller will thereby lose their ability to seek loss of bargain damages for loss of the transaction. So that is a little quick excursion on the nature of a deposit so far as it's relevant to this video series on forming a contract. The last thing that we need to briefly just flag for a future video series is our discussions on when a deposit is paid, but then things go very wrong and pear-shaped, how a buyer can recover that money back, or in the seller's case, if the buyer has defaulted, how the seller goes about retaining the deposit. They will be discussed, as I said, in a future video series, so stay tuned. And that's pretty much all we need to talk about for formation of contract in this video series. Thanks for watching, and as I always say, if you have any queries or questions, please don't hesitate to contact me by any and all means possible. Other than that, I look forward to seeing you in a Zoom tutorial sometime soon, and apart from that, it's bye for now, guys.